Hey guys, welcome back to Fathers Have Rights. Last time we went over the understanding of the weaponization of our justice system, as well as the weaponization of all systems. And in this video, we're going to get into number 3 together. Last time we discussed number 1 and number 2. The system implemented on this earth is the serpent system, okay? And they have a set standard of laws that they follow. The serpent is very legalistic, okay? And their system is weaponized against individuals, anyone coming against them. Let's say someone filed a lawsuit against them, or even followed a personal lawsuit against one individual instead of a major lawsuit. It could be just against a civil suit against one individual. But if that individual happens to be a part of their system, they will use their weaponization against you in a form of gang stalking and gaslighting. And that's what they do. It is a set coordination of attacks. And we are going to get into how that system is set up. Before we get into number 3, if you would like to see how that system is set up, let me scroll to number 3 first, and we'll go over number 3 together. One of their laws that they have written, Earth Law. Last time we went over CAPTA. Today we're going to go over number 3, okay? The protocol of what to do when you're being attacked. Okay. So number 3 is torture and identifying 18 U.S.C. 2340 through 2348. Torture Act versus Domestic Torture Act within the U.S. First, let's understand their weaponization, okay? And let me show that on the screen real quickly of how their system is set up. Okay. Let's draw a triangle. Okay. This is the image. We all know what the image is. Okay, let's draw. Let's not draw here. We're gonna just paste. You have one individual here, another, and another, okay? This individual is to recruit another 3 and another 3. Okay. This one is to recruit 6 as well. This one is to recruit 6 as well, and here too. Okay. Okay, you get the hint. Now each one does the same thing. So there are individuals of all facets of society. We're talking about pharmacists, doctors, law clerks, attorneys, etc. You'll see a bunch of them in all facets of society, okay? So you get the system. So it's a recruiting system, and it grew and grew and grew and grew and grew. Okay, enough of that. Now you understand how they're all working together. That's why when Jesus said leave the world, he literally meant that you will be gang stalked by neighbors. If you file something in court, forget it. If there's just 3 people in that court, forget it, okay? You're going to have a whole system against you. If you do anything against one person here and they're part of their system, this whole system is going to come after you, okay? That's literal. That's what the gang stalking and gaslighting is. That's why in the Bible it says there will be persecution of the righteous, and that's exactly what their system entails. God will prevail. That's why you stay in faith and stay in the Bible, and God will prevail, okay? Now let's talk about the investigations that we discussed before. Today we're going to go over number 3, torture and identifying 18 U.S.C. as we discussed. There's a definition of it. Let's read the definition first. This is a federal torture act enacted as part of the Foreign Relations Authorization and amended over time. It criminalizes torture committed outside the U.S. by or against U.S. nationals or persons present in the U.S. The statute implements the United States obligations under the United Nations Convention Act Against Torture and Other Cruel, Inhumane, or Degrading Treatment or Punishment, CAT, which in the U.S. is ratified in 1994. Domestic torture, acts inside the United States that would qualify as torture under the international definitions, is not covered by a single dedicated federal torture statute. Instead, such conduct is prosecuted under existing federal criminal laws, civil rights statutes, and constitutional protections. 18 U.S.C. shows you a deprivation of rights under color of law. Assault and battery is assaults within special maritime and territorial jurisdiction. Federal laws criminalizing various forms of assault and related violence in areas of federal jurisdiction. State-level constitutional protections include the 8th, 5th, and 14th Amendments. These U.S. constitutional amendments provide fundamental safeguards against torture or cruel treatment applicable nationwide, and the 8th directly to federal actions, and 14th extends protections against state actions via incorporation. So, 8th Amendment prohibits cruel and unusual punishments inflicted by the government. 5th Amendment protects against deprivation of life, liberty, or property without due process. 14th extends due process and equal protection to state actions. How about when the torture is inside the U.S. against an actual citizen? Okay, so acts that would qualify as torture under the international CAT definition are prosecuted under the federal and state laws rather than dedicated torture statute. Federal level relevant statutes that you can apply is deprivation of rights under color of law, as I stated earlier. For assaults in special jurisdictions, you have 18 U.S.C. 113 for assault and battery. Such as in my cases, a lot of individuals were tased when they weren't even moving their arms or fighting the officers. They were attacked. They're put in harm's way. Their belongings are stolen. People get set up left and right. And this is what we're getting into. In state level, most criminal laws are state-based, so acts of torture inside the U.S. fall under criminal codes, aggravated assault, battery, kidnapping with injury, official misconduct, or specific state anti-torture provisions in few jurisdictions. The constitutional provisions were the constitutional rights I listed above. Let's talk about one of the cases out of the several we discussed in last episode. Defendants intentionally coordinated and subjected plaintiff to severe mental and physical suffering, constituting torture, tasing client A multiple times in different scenarios by police officers, brutally beaten multiple times, stalking, gang stalking, freezing of accounts, deliberate conspiracy to inflict more harm on him for the underlying goal of hindering his progress in court proceedings and preventing him from obtaining information that could further his claims and legal remedies. Our evidence demonstrates a prolonged and coordinated pattern of conduct involving criminal proceedings, family court proceedings, child support enforcement actions, mental health detention proceedings, probation and supervision actions, incarceration-related restrictions, financial deprivations, and termination of parental proceedings, all of which substantially impaired plaintiff and his liberty, property interests, family relationships, and ability to access the courts. Evidence reflects plaintiff's parental rights were progressively restricted, beginning with the dismissal of abuse-related proceedings and the subsequent modification of paternity orders, despite the existence of prior lawful paternity judgments establishing parental rights and placement. These restrictions were later relied upon in proceedings that culminated in the involuntary treatment of plaintiff's parental rights to all 3 children. Okay. Evidence further reflects repeated governmental involvement through law enforcement agencies, child support enforcement agencies, correctional institutions, probation and parole authorities, mental health officials, judicial officers, attorneys, and guardian ad litem. Collectively, these actions resulted in deprivation of plaintiff's liberty, property, parental rights, and due process protections. Evidence also supports procedural irregularities, denial of meaningful access to the courts, denial of meaningful opportunities to be heard, reliance upon unsupported allegations. This is what they were using as unsupported allegations in their reports. Barriers to maintaining contact with plaintiff's children, barriers to participating in family court proceedings, and barriers to challenging actions taken against him while incarcerated, detained, and under supervision. The record reflects numerous instances where plaintiff's incarceration, supervision status, emergency detention proceedings, child support enforcement actions, and financial restrictions were subsequently used as grounds to further restrict parental access, visitation, placement rights, and participation in proceedings affecting his children. Evidence further shows a pattern of cumulative harm through repeated legal, administrative, financial, and custodial actions that interfered with plaintiff's ability to maintain employment, preserve property, exercise parental rights, maintain family relationships, and pursue legal remedies. The evidence raises substantial concerns regarding due process, equal protection, deprivation of parental. Yeah, this is just my one investigation. It's 500 pages conclusion for one of them. Obviously, this is showing you evidence of coordinated conduct, intentional misconduct, concealment of material facts, failure to preserve evidence, reliance upon unsupported allegations, and actions undertaken in bad faith with governmental immunity, qualified immunity, judicial immunity, quasi-judicial immunity, prosecutorial immunity, or other immunity defenses cannot apply to actions taken outside lawful authority in violation of constitutional protections or in furtherance of intentional misconduct. Taken as a whole, the evidence supports allegation that plaintiff was subjected to continuing course of conduct designed to isolate him from his children on purpose, impair his liberty on purpose, damage his reputation on purpose, restrict his access to legal remedies on purpose, interfere with his ability to maintain family relationships on purpose, and deprive him of constitutionally protected rights through a combination of criminal, civil, family court, administrative, correctional, and governmental actions, all of it coordinated on purpose. It is a weaponization of the entire system against us. So what is a protocol for someone addressing domestic torture or severe abuse and weaponization of the justice system? Truly, most people get beat up so bad by these individuals, they give up. And that's what breaks my heart. They literally give up. They have nowhere to turn, and they become homeless, and they just utterly give up. I've put this protocol together because it's good for us to just read their law and see how we can have grounds of standing up for ourselves, right? The protocol outlines a general framework for documenting, preserving, evaluating, and pursuing remedies relating to allegations that Client A was intentionally subjected to severe physical pain, psychological suffering, intimidation, coercion, excessive force, stalking, and financial deprivation, and coordinated abuse through others' misused governmental systems, law enforcement powers, and associated actors acting under color of law. Okay, so this distinguishes the Federal Torture Act, which primarily addresses acts of torture, and how to address it within the U.S. because this is mental torture. Okay, to be gang stalked and gaslighting is mental torture, besides all the physical abuse he had to endure. Okay? Legal framework, the Federal Torture Act versus domestic torture. The Federal Torture Act criminalizes acts of torture committed outside the U.S. We discussed that. Domestic torture and severe abuse within the U.S., where similar conduct occurs, you could apply, we could read, I'm not an attorney, but I would personally read these laws. Remember, we have a right to act pro se on our own behalf. So get to know some laws, such as 18 U.S.C. 1983, 18 U.S.C. 242, Section 241. We also have excessive force claims under 4th and 14th Amendment. Excessive force claims are different than just regular claims, right? Substantive due process violations, assault and battery claims, intentional infliction of emotional distress, stalking and harassment, statutes, abuse of processes, malicious prosecution, conspiracy and retaliation claims, racketeering or coordinated enterprises where applicable. So, scenario. Weaponization against client A. So, we have evidence of the multiple tasing by law enforcement officers where he was not even moving or fighting back in any way. Repeated brutal beatings, psychological intimidation with the mail they send, and harassment, stalking and gang stalking, retaliatory surveillance, financial deprivation through freezing of accounts, coordinated obstruction, and inflicting ongoing harm, attempts to isolate, intimidate, destabilize, and silence him, and the right to interfere with his legal cases and constitutional rights. Okay, it's best to seek emergency medical evaluation. If you have a feeling someone's part of their system, get medical evidence from 2 or 3 doctors, okay? Photos and videos of injuries, keep your damaged clothing, screenshots, surveillance footage, GPS data and location history, audio recordings where lawful, financial notices relating to them freezing your account, all metadata and timestamps. All evidence should be secured, okay? And anyone that needs these documents, I'm happy to send it to you, so just feel free to reach out. Clients should maintain a detailed chronological log of documenting each incident. Remember, it's important to timestamp every move they make, even if you're in prison. If they move you from one cell to another, that is not by mistake, it is for a reason, okay? Date and timestamp it, because see what happens the next day or that following few days after, okay? So identify officers or individuals involved. So anytime someone moves you, write down their name, get badge numbers, keep statements handy during incidents, get copies of anything that anyone writes against you, ask for a copy of it right away. Anything from the court, keep it. Surveillance or stalking incidents, record, timestamp everything, okay? So the reason we want to preserve everything is because sometimes we went to do requests and they say, oh, it's not available, and all FOIA requests get denied. That's because they know what they did and there's a lot of people involved, okay? So if you have your own personal documentation, you will also then document, did a FOIA request on this and this date for this, I was denied the request. So you keep a record and recording of every single thing, okay? Stalking and surveillance evidence. Where stalking or gang stalking is taking place, document different vehicle appearances, preserve license plate information, retain screenshots, collect witness statements, preserve communications showing intimidation or surveillance, and document patterns of coordinated appearances or interference. Financial interference. Preserve bank statements and notices, document timing relevant to court proceedings. This even goes as far as deep as individuals. They have individuals placed in banks, okay? They have them everywhere. So document everything. If someone at your bank does something and it's relative to what happened in your financial institution with you the next day, like getting a notice or a lien or a hold, you will get the connections tied together and know who's tied to who. With your documented evidence, you will know who's teamed up with who, and it's not hard to identify once you tie the strings together to know who's coordinating with who in what governmental agency. As soon as I did this phone call with someone, this took place with my bank, and you will see their actions and what they do. Okay. So that's why documentation is key in every single number of this document that we'll go over together. Civil remedies, we could get into due process violations, but we all know how a lot of the systems have been weaponized, okay? Litigation, I want you to know that it's good to know that there are people that will be there to represent you. It is good to find someone you trust, and you do have a right to represent yourself. Okay? Now, deleted records by court. We know some records are deleted prior to the mandated time frame based on my own personal investigations and what we did. Specifically, when I attempted to records request for client A certain document, we were told on purpose in the court that client A was informed records do not exist. Records were retrieved and data recovered by us. Okay? The retention period was anything for criminal felonies for the state of Wisconsin is 50 years. Civil misdemeanor is 20 years. Divorce and family, 40 years. Estate and probate, 75. Adoptions, 150. Naturalization is permanent in the records for the court. Now, when it's only been a few years past a request, a record not existing, that's false. That court is supposed to have that record. Okay? So they didn't want to give up the records. However, we still got the records. So in this case, the records requested were deleted prior to the required retention period. Okay, so importance of taking evidence and corroboration. Claims involving severe abuse, coordinated misconduct, and excessive force, stalking, or retaliatory systems abuse do require substantial corroborating evidence. So just notate the strongest evidence is medical documentation, body camera footage, witness statements, contemporaneous recordings, financial records, metadata and timestamps, internal communications, chronological consistency across records. In today's age, it's not hard to have others be witnessing what you're going through, and there might be someone on the street that recorded what that officer just did to you and whatnot. Great, then you have multiple ways to get some footage, right? In case you're denied a FOIA request. Where multiple systems operate in coordination to inflict suffering, obstruct legal proceedings, destabilize the individual, or interfere with parental rights. Evidence demonstrating motive, timing, coordination, and retaliatory patterns becomes critically important. So this protocol recognizes the allegations involving weaponization of the system, severe abuse, excessive force, or coordinated retaliation, and prolonged mental and physical suffering may implicate significant constitutional protections and federal civil rights concerns requiring immediate preservation of evidence, specialized legal review, and prompt pursuit of available remedies. Okay, next time we'll go over right to life, due process, and Fifth Amendment. And the reason besides having our investigations and knowing their system is just whack, let's just call it what it is because I want to give someone hope out there, anyone that's dealing with this, where your rights have been violated, where they terminated your parental rights to either transgender your child or do whatever they're trying to do, which is really to destroy the family dynamic. it is so difficult to hold on and to not think there's a way out. Remember, God is with you and you have to be strong, okay? And Jesus will show you the way out. And I want to give someone hope to understand there are people keeping records of what's taking place. We do know what's been taking place in this system. And we don't want you to lose hope. I know a lot of my cases, they've destroyed the individual to the core level, to where their goal was to have them self-harm themselves. Most don't do that, but there are some that do that. But in my cases, this is a systematic weaponization that's documented from A through Z to show you how malicious they really are. They do not care if you become homeless. They do not care what happens to you. If you're once in their system and you try to get out, good luck. I mean, that's when they will really gang stalk you and ruin your life in every possible way. If you were never part of their system and one of who you were married to was, well, that's when they eventually take the children away from you to put them in that system, okay? So whatever you may be facing, you're not alone. There are a lot of people that have been going through the same thing. So just keep the faith and know that we are here for you. Thanks for watching Fathers Have Rights, and stay tuned to get into more of this system and us exposing it together. Thank you.